declaratory judgments. A cause of action for declaratory judgment does not seek money damages. Instead, it seeks to have the court declare something, okay? Rights, titles, duties, and obligations of the parties involved, all right? Again, I'm going to say it. Rights, titles, duties, and obligations of the parties involved. And like Mr. Anonymous says, he says there's no better place to get a declaratory judgment than in a small claims court because it costs you next to nothing to get it established, all right? Most small claims court venues are like 25, 30, 50, 60 bucks, somewhere in that neck of the woods. If you understand the Constitution, you can point out into the Constitution where it says justice shall be administered freely, without delay, without payment. You can utilize that. It shouldn't cost you a fucking thing. I have a lot of friends that file a shit ton of court cases and they pay zero for it because they understand how to utilize the Constitution and how to enforce it, okay? So if you understand that as well, you can do it. But again, the declaratory judgment is not to establish money damages at all. It's rights, titles, duties, and obligations of the parties involved. A cause of action for declaratory judgment does not seek money damages. Instead, it seeks to have the court declare something. Ergo, bona fide disputes over what is or is not covered by an insurance policy. Okay, not only is it rights, titles, interest, duties, and obligations, ladies and gentlemen, we can also, in our declaratory judgment, get facts established, okay? Facts that can be used in another court, maybe the district court or whatever, that we can then use those facts that have been established during the declaratory judgment and cemented. Now they become facts and evidence that we can use for our other cause of action where we are looking for punitive damages or whatever, okay? Suppose Jones is sued by Smith for tortious interference with an advantageous business relationship. Cause of action explained later, and Jones is covered by a business liability policy he believes should pay for his defense in the lawsuit, and if the judgment is entered against him, money damages claimed by Smith. The insurance company, on the other hand, may believe Smith's lawsuit involves an intentional tort. Tortious interference is an intentional tort that cannot arise from mere negligence, and that its policy does not protect policyholders from damages resulting from their intentional acts, which is what happens in most good faith bonds, fidelity bonds, crime policy bonds that are held by the county or blanket bonds or whatever. So pay attention because this shit's important, all right? What they're basically saying is when you go in and read the insurance policy, they're saying, let's just say I'm a roofer and I hire you to work on my job site. And I have in my rules, regulations, and policies when you signed up to work for me and you signed the contract that said within 4 foot of the roof's edge, you are to be on your hands and knees. And I find out that you fell off the roof within 4 foot of the edge of the roof while you were standing. Guess what? I'm not liable. Okay, it was in the contract. It was part of the policy. It was part of the rules implemented by myself to mitigate the risk of people falling off the roof, and you chose to ignore it. So guess what? Before your little ass hit the ground, you were fucking fired, and you carried full liability for your own ignorance, okay? That's how these policies are written up. They're really genius when you think about it. So when an officer cries, "Woe's me," the insurance isn't covering it, the blanket bond isn't covering my actions, they're saying, yeah, you operated outside the policy and the scope of your authority that was delegated to you. You made a promise, an oath, a commitment that you wouldn't do these actions, and yet you seemingly did do these actions. And most cops will say, yeah, but we learned in training that we could do these things. Of course you can. You can also jump out of a 10-story fucking building. Is it advised? No. Do people do it? Yeah. The odds of them surviving, slim to fucking none, all right? So, can you do it? Sure you can. Nobody can tell you you can't do a thing in this world, all right? But are there repercussions and consequences for your actions? Abso-fucking-lutely. So, did the insurance company or the lawyer or the legislator necessarily mislead and misdirect the officer in what he can and can't do? Not necessarily, because he's responsible for knowing the fucking law. Okay, after all, how do you enforce the law if you don't fucking know it? All right. In such case, it is common for insurance companies to file an action in a court seeking a declaration that its policy does not cover the loss Smith claims. The gist of the action is to determine rights, not to award money damages. Declaratory actions can only be brought in narrow circumstances, however. For example, one cannot seek the court's declaration that a particular tax is unconstitutional unless the party seeking declaration can show a special injury to himself that is different from that allegedly suffered by other taxpayers. The purpose of the cause of the action is to provide parties with relief from insecurity and uncertainty with respect to rights, status, or other legal and equitable relationships. In most jurisdictions, the cause of action is created by statute, so before filing an action for declaratory judgment, consult state or federal statutes, depending on the court you'll be filing in, along with local rules and applicable case law for the jurisdiction. Elements. A party seeking declaratory relief must first make clear to the court that 1. There is a bona fide, actual, present, practical need for the declaration sought, and 2. The declaration deals with present, ascertained, or ascertainable state of facts or present controversy as to a state of facts. Anticipated future controversies will not support the action. 3. Some right, power, privilege, or immunity of the complaining party is dependent on the fact or facts or the law applicable to the facts. 4. Some person has or may have an actual, present, adverse, and antagonistic interest in the subject matter, either in fact or law. 5. The adverse and antagonistic interest is before the court by proper process or class representation. 6. The relief sought is not merely the giving of legal advice by the court or an answer to questions founded merely in curiosity. The first question to be reached by the court and first issue the defendant should raise to avoid or dismiss the action is not whether the plaintiff will succeed in getting the declaration he seeks, but whether he is entitled to a declaration in the first place. Each of the foregoing elements must exist and be alleged by the complainant, or the defendant can succeed on a motion to strike or dismiss the complaint. The fact that the court may refuse to declare what the plaintiff seeks or declare otherwise than what the plaintiff wishes does not divest the plaintiff of his day in court if each of the elements is present, unless the plaintiff shows he has a bona fide need for the declaration based on present ascertainable facts. The court not only lacks jurisdiction to render relief sought, but also lacks jurisdiction to entertain the action, which it may dismiss sua sponte. Sua sponte means on the court's own motion. Defense. As stated above, the first offense is by way of a motion to dismiss for failure to state a cause of action for which relief can be granted, i.e., if any of the essential elements is missing. For example, if what the plaintiff actually seeks is what amounts to an adversary opinion based on a hypothetical state of facts which have not arisen and are only contingent, uncertain, and rest entirely in the future, the court lacks jurisdiction to even entertain the complaint. Defamation. A cause of action for defamation arises from false, unprivileged communications that exposes plaintiff to distrust, hatred, contempt, ridicule, or obloquy, obloquy, oblique, or which causes the plaintiff to be avoid or has a tendency to injure plaintiff in his office, occupation, business, or employment. If the natural and proximate consequences necessarily cause injury to the plaintiff in his person or personnel, social, official, or business relationships, wrong and injury are presumed or implied, and such publication is actionable per se. If the publication is communicated in print, as in a letter or a newspaper article, the defamation constitutes libel, L-I-B-E-L, I think I'm saying it wrong. I think it's libel. If communicated verbally, as by TV newscaster or politicians making a speech, the defamation constitutes slander. So slander is something that is orally uttered versus defamation is something that is written, okay? Both libel and slander fall under the heading of defamation. Elements: 1. Publication by speech or print or of false and defamatory statements regarding a private person as contrasted with public figure, see below. 2. Unprivileged communications of the publication to at least one other person. And 3. Fault amounting at least negligence on the part of the publisher, i.e. at least lack of reasonable care as to the truth or falsity of the communication. And 4. Publication is actionable per se or cause plaintiff provable or presumable damages. The most important thing to consider before filing suit on this cause of action is in determining the amount of your money damages. The fact someone calls you a thief may be defamation. However, unless the defamation causes you actual measurable damages, a lawsuit for defamation is worthless except to prove the statement false. Plaintiffs suing for defamation frequently spend many thousands of dollars on costs and legal fees only to recover a nominal amount because they cannot prove actual damages. For example, if you are a bank president and lost your job because the head teller told the board of directors you are a thief, your damages are provable or presumable. If you are a newspaper boy embarrassed by one of your delivery customers shouting down the street after you thief, it's not likely you'll collect enough by filing a lawsuit to make it worthwhile. You might be given a chance to prove in court that you are not a thief, though, of course, proving a negative is the hardest thing we ever prove in life. And you can't prove a negative. It's just, near as I can tell, it's impossible. But it is improbable your damages in terms of money could be more than a few dollars at best. Courts sometimes award merely $1 nominal damages in defamation cases, establishing on the public record that the publication about you was false, but provided nothing in the way of a financial compensation for your trouble or embarrassment. If in doubt about the ability to prove the amount of money damages approximately resulting from the false publication, unless it is extremely important to prove the falsity of the publication in the court of law, let it go. Not all wrongs can be righted in court, and nowhere is this more true than in defamation cases. Caveat: if you are a public figure, ergo a politician or a professional athlete, you may be unable to sue for defamation unless you can show the publisher intended his statements to injure you, i.e., that he made a false statement about you with actual malice. This is why we so often hear comedians making fun of public figures, saying things that are certainly unlikely, if not, in fact, untrue, yet doing so in jest, ingest, in jest, unless actual malice intent to cause injury can be proven. However, the public figure cannot bring an action for defamation. We disagree with this doctrine. However, it's law by a decision of the U.S. Supreme Court in New York Times versus Sullivan, 376 U.S. 254, 1964. I believe, if I'm not mistaken, the New York Times versus Sullivan dealt with the fact that the news media is nothing more than a source of entertainment, and therefore they cannot be sued for lying or falsifying a record because they have no duty to actually bring forward any factual information. So the news media is nothing more than a source of entertainment, and thus they can lie, create any story they want with impunity, more or less. Defense: truth. If the allegedly defamatory statement is true, there can be no action, and plaintiff has the burden of proving falsity. The defendant does not have the burden of proof, to prove truth. This raises an important fact about arguments in general, in that it is far harder to prove a falsehood than to prove a truth. Another reason why wisdom counsel against bringing bringing an action for defamation except in the most extreme cases where it is necessary to do so. Absolute privilege. Allegedly, defamation statements made in judicial proceedings are privileged. If this were not so, every party prevailing in a lawsuit could sue the other party for making false statements during the case. Statements made out in the hall, however, are not privileged. First Amendment. Courts may refuse to hear cases brought against representatives of religious order or denominations because of the First Amendment proscription against government being entangled with religion. However, the allegedly false and defamatory statements must be so entangled that the court would be unable to sort out the truth without crossing the line. Class of persons. If the allegedly defamatory statement is made about a collective race, religion, or other large group, the courts may refuse to hear the case. Of course, if the statement is Bob and Harry are thieves, that's not a large group, and the injured person has a cause of action. On the other hand, if the statement is all Nazis are murderers, no court will hear an action brought by a single member of a Nazi party claiming he or she has been injured by the statement because he or she individually is not a murderer. Public officials. If the would-be plaintiff is a public official, he or she must prove the defendant acted with actual malice, i.e. intent to injure, by making false statements. Actual malice is proven by showing the statements were known to be false or were made to be reckless disregard for whether they were true or false. The reason more public officials don't file suit against comedians and media pundits is that doing so exposes them to discovery of their closeted skeletons and, as stated above, wisdom counsel against suing except where absolutely necessary. Pure opinion. Everyone is entitled to an opinion. If you say to a neighbor, I think, or our mailman is a communist, the mailman cannot sue because you are entitled to an opinion, right or wrong. If you say our mailman is a communist and it gets back to the post office and your mailman loses his job, prepare for a battle. Only pure opinion is protected. When we come back, we'll be talking about duress. And again, we're just going through elements and different causes of action. And so, like I said, when we come back, we'll be talking about duress.